everyone for joining us again today. As you know, we got through only section 1 at the last 2-hour meeting. So one of our thoughts was to perhaps get a little more completed under our belt to get started today by going through the remaining sections rather quickly to find if there are any low-hanging fruit. In other words, if there are sections that would not require much, if any, conversation in order for the committee to be okay with it. And then we will circle back to cover the sections that require further discussion. If that's okay with everyone, I think we would start then with number 2 in the recommendations. So Alexandra, if you want to share your screen. Okay, let me get this where I can actually see it. I don't know how people work with only one monitor. I love having 2. Okay, thanks. Okay, starting with number 2, looks like we have one pre-submitted comment there. Do we want to consider that first? Oh, actually, before we get into the pre-submitted comment, is this one that we think that we could handle pretty quickly, or do you think this is one one that we're going to need a decent amount of discussion? Burke, do you want to answer that question, or what do you want to say?
No, I just wanted to, since you raised it, Roxanne, I just want to say I think the pre-submitted comment came from me. There may be, I think someone may have, I think the Surface Transportation Board also joined in this, but just I think we had a general objection to requiring agencies to undertake a rulemaking process here, just on grounds of burden and burden on the agency's processes. So I don't know if that sparks a larger conversation for the group, but I just wanted to highlight that I had made that comment.
Okay, I think it probably will spark larger comments. So why don't we just skip ahead to 3 just for now, and we'll come back to 2 in a minute. Thanks, Burke. Okay, number 3 is saying that Congress should provide in 5 U.S.C. 552 that agencies must develop and post on their website proactive disclosure plans, etc. Is this one that folks think would be amenable to quick consideration, or is this one that's going to need more discussion? Any thoughts? Alan Morrison?
So I guess the question is whether 3 is subject to judicial review. And I had the same question about 4 also. That is, to maybe ask the consultants whether these should be made judicially reviewable or not, leaving aside the question of, suppose they don't do it. Suppose they require it and the agency doesn't post it. Should it be subject to judicial review? Maybe we don't need to say anything about it. And the same as they don't designate an officer for overseeing. Leaving aside who might have standing.
Well, it seems to me that this one probably won't require a lot of discussion. So do any of the consultants have a response to Alan's question? Basically, what enforcement mechanisms would there be for agencies who don't post their disclosure plans? Margaret?
We discussed it briefly, but not extensively. And I believe that our general feeling was that, like other required agency actions, the regular APA review would be available in instances of failure to comply with the requirement.
Thank you. Michael, did you have anything you wanted to say? I see you lowered your hand.
Well, only because I was going to say what Margaret said. I guess I'd add, why wouldn't it be ?
Well, I guess my question would be, would it be subject to, as Margaret said, regular APA review, or would it be subject to FOIA review? Because we've had differences of opinion on it, and I don't think in the end it may matter so much. But if the agency doesn't post these materials here, this recommendation would say you have to go through a review under 552A3, which is somehow different from APA review.
Margaret?
Maybe we should take that up in connection with the judicial review section and think about it then.
That might be right. I think we were envisioning APA review, but as you can see, the recommendations don't have specific language on that point. Although for reasons that we described in the report, we were considering the failure to disclose records affirmatively under FOIA, including the new requirements to be subject to review under FOIA. This kind of requirement seems more like a APA-like thing, for lack of better justification. But I think perhaps maybe specifying that somewhere would be consistent, I think, with the consultant's view of how it would work.
Aaron Nielsen?
Yeah, I guess my point would be, if does anyone have a problem with the substance of this? We are going to have a separate discussion of the judicial review provisions later on, which I think is going to get more attention. So just on the actual substance, does anybody have a concern with 3 as it's written on the screen? Would be my thought.
All right, Burke?
I mean, just to flag that we do have a problem. I mean, I think we prefer to not have this requirement placed on agencies, and that was a subject of a pre-submitted comment.
Okay. Were there, Alexander, were there other pre-submitted comments on 3?
The only one that I have notated on the side is the one from Burke, yes.
Okay, all right. So if there's no other, Ted, go ahead.
Yes. Yeah, I think we would echo the comments from Burke. The grounds. I mean, I don't know if it's been explained yet, but from our standpoint, we think something like this is overly burdensome, and in fact, this agency is required to do a lot of management plans every year for addressing many different issues, and this is just another one that overburdens our agency, considering we are a small federal agency that doesn't have tremendous resources to deal with this. And so we think that that's one reason. The second would be that it does create these. It's just going to create more litigation for us to have to deal with, considering probably over not just whether we obviously would do a plan if we were required to, but the content of it and what satisfies it and what doesn't. I think this is a very significant litigation risk for agencies, because it's not clear what we need to do or not do, and so I think we're heavily concerned about them.
So Ted, am I understanding correctly that you and Burke, your suggestion would be that this number 3 be deleted completely? Is that a suggestion?
Yes, 3 and 4, because 4 is dependent upon 3. But I think they would both be. We would, at least my view is that these should not be included.
Okay, Ray Peeler.
Yeah, I'm just to echo what everything that Ted said, including the context of, as a small agency that already deals with a fairly significant FOIA workload and FOIA litigation docket, adding another thing that people can sue us over is not something that we would favor.
Okay, John Allred.
Yes, I just wanted to echo Ted's points, but also from the perspective of a larger department with many subcomponents, and the idea that we have to have the plan. We do lots of plans, but if we have to have a plan that potentially we could be sued over for some portion of the agency not actually following the plan as stated, is pretty problematic, I think.
Okay, Ellen Morrison.
Mute myself. I consider these 2 provisions, 3 and 4, to be much less significant than the rest of the proposals. And I would hate to see this whole recommendation go down if agencies opposed it. So let me propose an alternative for both 3 and 4, which is that Congress, I'm not sure the word's exactly right, but this is the point. Congress should require the Office of Management and Budget to assure that agencies develop, leave aside post and if feasible, post on their website disclosure plans. And then the same thing is true with regard to 4. So I'm just proposing that as an option that is, Congress would require OMB to do it, but it would not be judicially reviewable. Would that satisfy the objectors?
So you're suggesting leave 3 and 4 as is, but
No,
add language,
no.
or just
I'm
changing it
suggesting
to
that
the OMB?
Congress should require OMB to assure that agencies develop affirmative disclosure plans, et cetera, et cetera. I don't want to try to draft it here. I could draft it, but I don't want to try to do it while I'm speaking now. I could send in a draft later on. But the idea is that we want agencies to do it, but we should have. I agree. I'm a big proponent of judicial review, but I think this is probably not a very good use of judicial review. That the Office of Management, this is a management matter, and Office of Management and Budget should be dealing with management matters.
Okay, Bernard Bell.
Yes, so just for information, proposal 3 is a very stripped down version of what the consultants proposed, which was a fairly, or at least initially proposed, which was a fairly detailed listing of things that would need to be in this disclosure plan. And the concern was that it was too prescriptive, that it was too detailed. So I think that should be taken into account now with regard to concerns expressed about it now being ambiguous and agencies not knowing what's required. So part of that is essentially a reaction to exactly the opposite criticism, that it was too detailed. I would also just say in general that, and I know Kara will probably say this in much more detail and better than I can, but I think the consultants thought this is a pretty important part of this proposal in order to have agencies have an obligation to manage for themselves how things would be disclosed. So it's not an issue of what is to be disclosed, but how agencies will assist the public in finding the things that are on their website and keeping them updated and those sorts of things, which in some ways is just as important as what is to be disclosed. Thank you.
Thank you. Carrie Colonnese.
Sure, just to follow up, can you hear me okay? By the way, okay. Just to follow on Bernie's point with a couple of things. One is that this kind of planning, it seems to me probably something that many agencies are already doing for themselves. Or I mean, I don't know how people in agencies are deciding what goes on their website and what doesn't if they don't already have some kind of plan. And this is a way of saying, just formalize that and put it up on your website so the public knows what they can and cannot find. So that's one thing. The second thing is that this is really the way to customize or create a bespoke approach to what the agency is going to do in response to the other requirements. And I know we've had a lot of discussion already on various recommendations about whether certain kind of documents an agency has at all, or maybe has a lot of, and yet there wouldn't be probative value for most of them to put online, or it would be excessively burdensome. And this is just the opportunity to tell the public that that's what you're doing. That's really all that this is doing. And let me add a third and final point. Bernie did mention that this is more of a disclosure to the public. Quite frankly, disclosure to people in the agency and on Capitol Hill and about where information can be found. But there is one kind of substantive implication of this recommendation that I want to at least make sure the committee is aware of. There's a whole category of agency legal materials that are not included in these recommendations, and that's guidance material, guidance documents. That's been a matter of some public concern, of concern to ACUS over the years, and the recommendations that came out of the consultant group were not to create and try to create a one-size-fits-all approach to guidance documents for all agencies, because I don't think that's reasonable, or maybe not even possible. But this affirmative disclosure plan is really the one place where agencies would be asked to deal with and at least disclose to the public how they are making available various guidance documents. And in that respect, it does track ACUS recommendations with respect to guidance documents. I know there was a question about some of these recommendations, whether they include current materials or past materials. That too is subject to an ACUS recommendation in the past. And that recommendation largely followed this management planning process, giving agencies maximal flexibility to decide those questions for themselves about what they think is most important for the public to have, what is most feasible for the agency to be able to disclose affirmatively, and then just let the public know that. So anyway, I do think as you go forward with your deliberations, if anybody is wondering where guidance documents fit into the whole picture of what the consultants were recommending, this was the place.
Great, thank you for those comments. Since we were trying to do sort of low-hanging fruit here, obviously this isn't low-hanging fruit. I'm going to call on John Allred next, but what I was hoping to do was take a quick poll to find out if people would like to keep this in or continue discussing it for further wordsmithing, et cetera. But I'll do that after we hear from John and Michael.
Thank you, and I'll keep it brief. I just wanted to say thank you to the consultants, and I just wanted to reiterate I don't think the idea of a plan is bad. The FAA was part of a GAO audit about proactive disclosures, and that was very helpful in simulating improvements to the process. I think would be a significant concern with publishing a plan that we would be held for any deficiencies, right? Other than an audit, right? We have a plan, you didn't comply with the plan. Here are recommendations to comply with the plan. That would be fine. The ability of dissatisfied public members to sue us over our failures to comply with every portion of the plan would be a great concern.
Thank you. Michael Hurst. Oh, you're still muted.
Sorry about that. Just one last point, consistent with what my co-consultants have said, is to just note that something very much like this requirement exists in the E-Government Act in 207 F1, which requires agencies to establish a process for determining which information they will make available and accessible to the public on the internet, to develop priorities and schedules for making government information available and accessible, and to put all that stuff online, to make such available for public comment and to post such final determinations, priorities, and schedules on the internet. So this isn't a massive deviation from what you can already find in the US Code.
Okay, thank you. If we could do just a quick vote on two options. Option one, that 3 and 4 be deleted. Option 2 is that 3 and 4 we circle back to and we spend more time wordsmithing and considering edits along the lines of what Alan Morrison suggested. So option 1 is for the committee members to vote whether we just go ahead and delete 3 and 4. So raise your hand if you're in favor of that option. Okay, and then please, committee members, please raise your hand if you're in favor instead of keeping them and working on editing them. Oh, a tie. Okay, so why don't we just put a pin in that and we will circle back to this language in a bit, see if we can actually find anything that would be quick hit for us to get through here today. So let's skip to what's now numbered 6. It's various provisions of the E-Government Act, suggesting some edits to that. Chris Walker.
Sorry, no, I'm slow on voting.
Oh, still voting. Okay. So on 6, sub A is to delete section 206B of the E-Government Act. Alan Morrison.
I'm sorry, I thought we were gonna skip over the Office of Legal Counsel, but I see it's now. What is the status of that? Oh. I thought that the Office of Legal Counsel. I'm sorry, I was looking at the wrong thing. I apologize. I got out of order.
Okay, does anyone have any thoughts on 6A, deleting section 206B of the E-Government Act? No one seems to have any problems with that. Let's go to 6B, which is delete and B in 207 F1A2, which I'm presuming if you're deleting 206B, you also have to delete a reference to it as well. So doubt anyone would be concerned about that. Hearing no concerns, 6. Oh, go ahead. Someone had a comment?
Sorry, yeah, just to be clear, the and B is in section 207F. It's a reference to 552B. So
thank you.
It's actually that these two are completely distinct. I still think it's a good idea to get rid of and B, but not because it's not just a reference to the thing we just deleted.
I appreciate the clarification. Sorry about that. Now, does anyone have a comment on that? Seeing no raised hands, 6C is eliminate references to the Interagency Committee on Government Information. Information's misspelled there, which no longer exists. Does anyone have comments on 6C? All right, moving on to 7, that Congress should provide by statute that each agency should, to the extent feasible, post each of its legislative rules on its website, etc. Does anyone have any comments on 7? John Allred.
Yes, I don't have any problem with posting the legislative rules. The posting the guidance documents associated with each rule is an extremely large lift, right? If that might be possible if we had some kind of centralized technology that, you know, that GPO allowed that to happen, but I don't see that being super feasible. I realize that there are some agencies with larger budgets devoted to this who could procure IT systems to do that. You know, we don't have the technology to do that. Procuring that technology is probably not really high on the list.
Thank you. Ted Hunt.
Yeah, I'm echo that comment. And I would say that certainly we don't have a problem posting our legislative rules on our website. I think we already do that. But the concern I have was the last part of this, where it says, and with such, you have to include significant adjudicative opinions interpreting or applying it. And the concern I have with that is, I mean, again, I think we may discuss this before, but that requires a judgment call. That's sort of a legal determination that you know, I'm not sure what exactly that means. Significant adjudicative. I mean, I know what that means in the general sense, But if we have decisions that apply it and interpret it, some may be significant, some may be not, but that's really a judgment call. So I don't really think are we going to be held responsible for that somehow if for some reason we don't identify a specific case that or opinion that the board has put out interpreting or applying a rule? Does that mean that we're going to be somehow liable for that if for some reason it's not understood by somebody in a proceeding? It just seems it's opening a door here that we have to make a judgment call about what we think is significant, which may or may not be what others may think or practitioners out there that are appearing before us. So I mean, I think guidance documents could be tough if you have a lot of them. Our agency doesn't have very many of those, so it's not as huge of an issue, but having to decide every decision comes out, does it actually implicate a legislative rule, and is that significant, and are we going to put up on the website? And it's just a burden, and I think it creates issues that we don't really have a good answer whether something's really significant or not, and so it creates those types of disputable issues. And so I would recommend not including that part.
Thank you, Ted. I will second Ted's comments. I don't know how we would do this. I don't know how we would keep it. I don't know how we implement it or how we would keep it up to date. I think it would be quite difficult from at least my agency's perspective to try to comply with this. Any other comments on 7? Aaron.
So if we're going to drop the second part, which I'm not saying we should we also get rid of to the extent feasible? Because surely it's feasible for every agency to post the legislative rules on its website. That seems, if we're not going to do agency guidance documents, surely the legislative rules themselves.
Thank you. Alan Morrison.
I believe agencies are already required to post their legislative rules on their on their website, or made available. So this is not this is a nothing burger. But is this? I guess I'd like to hear from the consultants as to why they thought this was important, especially with the guidance documents. And by the way, I would certainly support including the word principal guidance documents or significant guidance documents. And I guess I just don't understand the problem. They've got to the extent feasible. Maybe this should be, this is not subject to judicial review. It's committed to the agency's discretion. I wouldn't be troubled by that at all. But the notion that we're not even telling agencies they should do this, let alone that Congress should do this. I mean, maybe we should just say agencies should provide that they must post this and so forth and so on. But to say nothing about guidance documents and significant adjudicative opinions linked to their rules seems to me to be undercutting a lot of the work that the committee, that the consultants did, and makes this into a pretty much nothing this particular one into a nothing recommendation.
Chris Walker.
Yeah, I agree with Alan. I mean, I would think moving to the extent feasible later, so to post each of its legislative rules on its website, and to the extent feasible, any related agency legal materials, including such as significant guidance documents and the like. I mean, I think that, and if we really wanted to water it down, you could add a should consider to that second part. But I wouldn't want to do that. I mean, I mean, if it's a significant agency guidance document, I don't know. I'll stop there. But I think I'm with Alan on that front.
Thank you, Carrie Colonnese.
Sure, and maybe I'm at the risk of sounding a bit like a broken record here. If you adopt the full suite of recommendations along the lines of what the consultants recommended, agencies can figure this out themselves. If there's an agency that, only has a few guidance documents for its rules, shouldn't be a big burden, just put them online, right? But if you have another agency, like some of the agencies you hear from in the committee meeting where this would be a burden, fine, then just let the public know that you're not going to be doing this. for all things, or maybe just for significant guidance documents. The risk here is you've got so many different agencies throughout the federal government. What we're trying to do with the package of recommendations out of the is sort of set a bar that should be standard across the federal government, but give agencies flexibility to customize and carve out when they need to carve out. Because you're just not, either you're going to end up in a situation like what Alan is saying, where you're going to have a nothing burger of a recommendation. It's not really setting any expectations or aspirations, if you will, for affirmative public disclosure. Or you're going to try to somehow micromanage this for every agency, which I don't think is possible. So I think the best solution really, and what the consultants really came to, is let's think about what sort of should be an ideal practice when possible. And if not, for specific agencies, well, then just fine, let the public know that that's not possible. And then everybody kind of knows. It's not just in discussions in ACUS committee meetings where people are hearing that, well, we've got too many guidance documents, this would be too burdensome to connect them with the legislative rules. Let the public know that.
Thank you, Carrie. I have a question, because perhaps I was not understanding the intent in this section, because the way I was reading it, I thought what you were trying to say is that you post your rules, which I would imagine most or all agencies do, but then within the rules, you embed links within the rules to guidance documents, as opposed to having a separate link to here's all the guidance documents in either another section on the website or even in the same landing page on the website. I thought you wanted the links embedded in the rules, and that's where I was getting tripped up, because I thought, I don't even know how we would do that and how we would keep that up to date.
Would you like me to just clarify on that point?
Yes, that would be great. Thank you.
Sure. I mean, so again, another point that may sound like a broken record is that every one of the recommendations we're making in the consultants report have been implemented by some agency. And the way agencies, what we have in mind here are those agencies who have in place a page about a rule, and then they have links to associated materials with it. And it's not really to embed it in the rule itself or the rule document, but on the web page where you have the rule available, there is something that would alert the public to the fact that, hey, there may be some guidance documents, for example, associated with this rule. And Roxanne, you're exactly right. It could be adapted at different agencies in different ways. So some agencies, it may well be, a link directly to that guidance document right there. Another might say, because we have so much guidance, for example, let's put a link to at least alert the public that there may be guidance, and go to our guidance page, let's say, to search for guidance. So that's really what's intended here. And I think we could pull up, if people are interested, a few examples to show you how agencies are doing this.
I just put one in the chat.
Okay.
Thank you. Thank you for the clarification, Carrie. Bernard Bell?
Yes, so I mean, the basic rationale for this is that everyone knows that oftentimes rules will have glosses put on them by agencies, that reading the rule is not going to really tell you what the rule means. And so this is essentially something that will help members of the ordinary public who may be protected by these rules or may be subject to regulation of their conduct by these rules, to really get a head start on what the principal glosses on these rules are. So again, this is something where it's not so much what has to be disclosed. All this stuff has to be disclosed. The question is, can we disclose it in at least one way that people can easily figure out what the documents they need to look at. So I think that was the basic rationale for making this suggestion. Which would, was not my suggestion. It was actually, I think, originally from Michael Hertz, and I thought it was a suggestion, but I don't know if he wants to elaborate upon that.
Okay, thank you. Chris Walker. Okay, all right. Anyone else wanting to comment on this section 7 at the moment? Ted Hunt?
Yes, no, I certainly appreciate the intent of it, and I certainly think this is a laudable goal for the public to to understand not just the rule, but here's what, if there's glosses on it, if there's other interpretations. I think that, yes, it's helpful to the public. I understand that. I still have an issue with, as an agency being required to decide what's a significant adjudicative opinion, interpreting or applying it, because I think that is very subjective, and depending upon the situation that's being presented, and as somebody coming before the agency may say, we didn't know about this because you didn't post it, and then you get into this battle with them about that. I really think it's problematic for us to have to put that type of legal gloss on it to say we think this is definitely a significant opinion. I'm guessing that FTC does, or other agencies may do this. I have concerns about that. It's less so with the guidance documents, because I think guidance documents are actually tailored to a specific rule and say this is what we're trying to add some interpretation onto this, so I can kind of understand that a little bit more. But that's my general objection. So, but maybe I think somebody suggested early, I think it was maybe Chris, that said maybe we could just do this as they should do this, and maybe that would allay my concerns a little bit more, because I know to the extent feasible is in there, but that's always, there's somebody can argue, well, it was certainly feasible for you to do this, but should is a little more, gives us a little more wiggle room for agencies to decide whether or not it really has the capability to do with that. Because I know for our agency, we put out a lot of decisions every week, and to have to sit down and have to interpret them and say, okay, this one goes and links with that rule, or this one links with that rule, and you must put it on the website now. So this is, I think, extremely burdensome, and creates problems if we aren't getting that decision right. So, or get that determination correct.
Thank you. Thank you very much. Michael Hurst?
So just a couple of quick things. First of all, to answer Alan's question about why the hell are we even bothering to say to put the legislative rules on the website, don't they already have to do it? They more or less do, but the place that requires it is 207F, and it's, the e-government act of the e-government act, which doesn't explicitly say rules. It says information about the agency. And as a practical matter, yes, people do this, and the OMB is supposed to write guidelines about what goes on agency websites, and the e-government act explicitly requires it to include in those guidelines something about rules, and OMB has never done that. So yeah, as a practical matter, agencies perceive themselves as having to do this, but as a sort of lawyer's statutory wording matter, this is clarifying and adds a marginal change. But obviously the more important point here is about the supporting material, if you will, about the rule. And as to that, I sort of, I think Bernie explained it very well. I did post in the chat, for those who didn't see it, an example of the kind of thing we're talking about, which is what the FTC does, which is to post rules and then have links to the various sorts of supporting documents. Now, of course, the FTC, I understand it has fewer rules than some agencies and more resources than some agencies. I get it, but it is, I think it's a nice model of the sort of thing that we had in mind. The third thing is, at some point, we made, I don't know, the dynamic of the conversation about this is the same dynamic as the conversation about each of the proposals, right? Which has been the consultants aimed high, ACUS cut back a little bit, and folks from agencies on the committee just feel, oh my God, are you kidding? This is just too much. You're in the real world, we can't do this. And, that's just clearly a fundamental divide here, and an example of where you stand depends on where you sit. And we've seen this phenomenon in lots of ways. I think all I would say is, if it was easy, we wouldn't need legislation requiring it to be done. That when Congress steps in to require something, it's because there are lots of forces keeping it from happening, even though it might make sense. And I hear you on the resources issue and the burden, and I can't pretend to know more about it than folks inside the agencies know. Of course, you guys know more than those of us outside the agencies. But I also discount it a little, to be perfectly honest, precisely because, if we always just said, gosh, this would be hard, therefore we shouldn't do it, then nothing gets done. And I do think, I'd go back to first principles, that these materials are actually extraordinarily important. That's what all the fight over the last 10 or 15 years about guidance documents and abusive guidance documents has been about, in one form or another, that these are hugely important documents that people need to know about. On the right, there was the Trump guidance EO. Lots of people on the left thought the stupidest thing Biden did on his day one executive orders was to withdraw the Trump guidance document. That was the one thing that Trump got right for lots of people on the left. And so the resistance to publicity for guidance documents and adjudicatory decisions, which are another form of guidance in a large sense, I get where it's coming from, and we can all agree to blame Congress for not adequately resourcing agencies. But I'm just reluctant to sort of lay down and say, oh, okay, if it's too hard, you don't have to do it.
Thank you. Margaret Polka.
Following Michael's comment, I feels hard now, but I was just gonna say that although I second all of that, on the narrower point of this recommendation and the affirmative disclosure plans, I just want to point out that if we scrap both of them or reduce each of them to something that is, Alan's nothing burger, I think we've really lost a big part of what we found in our research to be the public's barriers to accessing agency legal materials, because one of the principal problems, some of the problems are, there's some sets of materials that are not available, but another big set of problems is materials might be technically available somewhere, but extremely difficult for the public to find. So searching and indexing, understanding how to find the relevant documents, and these two or three together recommendations were really our effort to get at that problem. And so if we're not going to do it this way, I'd like us to at least consider if there's some other way we can get at those problems, because for people who are not specialists in particular agencies or particular procedures, oftentimes the barrier is not that the document isn't somewhere, it's that they can't find it or wouldn't know where to look. And so affirmative disclosure plans were one way we thought of advising the public about how, what is available, where they can find it. It's almost like Alan keeps saying about indexing, sort of a version of indexing, right? For each agency to be able to say, this is what we have, this is what we publish, this is why, this is how you can find it. And then this one was really a way to say, for those things that are most centrally important about policymaking, that on an issue, so that a member of the public doesn't say, well, I'm looking for guidance documents. They say, I'm looking for, what does the agency have to say about e-cigarettes or whatever it is, right? And then all of it is in one place. And so I just want to sort of say that if we're thinking about what we're trying to achieve, if we cut these back this much, I think we've lost a big piece of what we found in our research to be the barriers to accessing agency legal materials. And we won't be addressing the how piece of it, the how to access them, how to index them, how to make them practically sort of available, not just technically available.
Thank you, Margaret. Jennifer Dickey.
Thanks. I wanted to echo a lot of Margaret's sentiments, that I think that this would be very, very beneficial to people who don't have fancy pants lawyers to help them figure out all the guidance that might be applicable to a particular rule, especially small businesses. And with respect to the concern that's been raised about significant adjudicative opinions, I guess I am not as concerned about that. I mean, obviously I'm not an agency, so I understand that, but I think most adjudicative opinions would be issued by an attorney. And I would think it would not be that hard for the attorney in issuing the opinion to designate whether they viewed it as significant and even to list what rules they thought it was a significant interpretation of, so that the agency could then simply use that sort of designation from the adjudicative officer to make it easier. And I think the separate question of like what harm could flow from, you know, an agency messing that up, like I think that's like a totally separate question as to, you know, whether that would affect the like liability of the agency or the validity of its, you know, action in another case. Like what I think that's sort of a separate question from whether they should disclose it. And I think as a matter of good government, putting where the guidance is, like the whole point of guidance is it's supposed to make the law clearer. And so putting it with the legislative rule seems to me to be a really important step forward.
So Jennifer, and anyone else, Carrie, I'll get to you in a second. At this point, someone has suggested getting rid of the word significant. So it would just be any adjudicative opinions interpreting or applying. But from what Jennifer's saying, she was focusing on significant adjudicative opinions. How do people feel about taking out significant and including all adjudicative opinions interpreting the rules? Carrie, were you to speak to that, or is Ted, were you going to speak to that?
Well, so yeah, I guess in a way, I just wanted to highlight when Jennifer was speaking, you know, and it's been raised by others, what is a significant? Who's going to determine that? Does including the word significant adjudicative opinion open the agency to just a flood of litigation? I guess I'd love to hear more, but I don't know how that would happen, because again, all of the materials that are covered by these recommendations are materials that are not exempt. Okay, so they have to be disclosed upon request. So if somebody comes forward to the agency and says, you know, you had a significant adjudicative opinion that you didn't list, you know, that should be listed here. I mean, then you know which the opinion is, and just it seems to me you put it on there. Why would you go to court over that if you could just list it on there? If it's something that's already has to be disclosed, and somebody thinks it's significant, you know, I think that, you know, may well be the way that this would play out, rather than a tremendous amount of litigation anytime somebody thinks there's some significant adjudicative opinion.
Thank you. Ted Hunt?
Yeah, I don't think that's not the scenario I was envisioning, Carrie. I was envisioning if we had a substantive decision taken to court on judicial review, and we relied upon certain you know, past precedent that the board has put out. And if it's not on the website and listed as significant, whether the court's going to actually give it as much weight or anything, they might say, the other side's probably going to say, wait a second, you didn't list this as one of your significant opinions interpreting this. So by doing this, you really can't hold us accountable for understanding that, or for the weight of the current board's opinion as to whether or not it should be upheld. So that's what I'm worried about, is that by characterizing it, we're basically saying, well, these are the things that govern this, and we might end up in a situation where we're under review for another decision and then there's arguments all made about whether we had disclosed that in one way or another. I'm not suggesting taking out significant. That's just my concern. I think you can leave it in. If we're going to have this should in there, I think that can be left in. It's just I'm generally concerned about that overall issue of having to make a determination to put it on there. We have a working, and again, I think this is probably a lot of other agencies, and I think it's probably because it's already required that all our major decisions, all our adjudications have to be available to the public. And so we have a database that, you know, obviously it's searchable, and you can search it by the rule and the rule number, and you're going to get, hopefully our database works correctly, because most of the time I think it does, but you're going to get every decision that interprets it. And so I think that's a way for the public to understand how our agency is applying whatever rules is at issue. But for us to be telling the public, well, this is the one, these are the ones you have to really know, I think that's borderline giving legal advice to the public, which I think is, okay in certain situations, but not if they're in the middle of trying to sue us. So, it's just those are my concerns about it. But
So before we move on, and Ted, since you had the floor, Ted or anyone else who had an issue with this section, how do you feel about the language that's been proposed, which is saying basically that agencies need to post their legislative rules and, to the extent feasible, providing links to guidance documents and opinions? Does this address the concerns that were stated?
I think for me, it's closer, and so I'm gonna have to think about it a little bit more here before we move on. But I think it's because it says should to the extent feasible. I think it gives us a lot of leeway to decide what really is significant or not, and that helps certainly.
Okay, thank you. Bernard Bell.
So 3 quick points. One is there's also a problem of information overload, essentially. So if we're taking out significant and just saying all adjudicatory opinions, that could also get people lost. In other words, 100 opinions interpreting some rule, but every case says these are the 3, I don't know, major case factors. So major case is really, the significant decision, and all the others are kind of noise, and I think it just at some point starts to be an information overload that inhibits understanding rather than helps it. The second point is that the way I interpret significant is that it is significant from the agency's point of view, and that there's not really any basis for saying, well, it's significant even though the agency doesn't think it's significant enough to link in this context. So I think agencies have a broad scope, would have a broad scope of reasonable discretion by the use of the word significant. I don't think it's for the courts to kind of tell agencies which ones of their opinions or guidance documents are significant. And then with regard to Ted's concern about any sort of estoppel arguments against the agency, you can't kind of cite this case centrally because you didn't say it was significant. I think there could certainly be language added that said that the designation or failure to designate an opinion as significant for purposes of this linking requirement has no bearing on the validity or the importance of the case in litigation. I mean, that's not very well formulated, but essentially saying that no inferences can be drawn in terms of court adjudications or even agencies' interpretations based on this judgment about what document is going to be linked and what's not going to be linked.
Thank you, Bernard. For that reason, at our agency, we don't designate opinions as significant on our website. We designate them as notable because we're not actually expressing an opinion. We're just saying this is something notable that you might want to pay attention to. John Allred.
Yeah, I just wanted to say, well, to answer Roxanne's question, I think that the language that converts this into a more hortatory language is good. I have to raise my hand to say it's not actually the case that, at least here for me, that the attorneys draft adjudicative opinions, and in a certain sort of perverse way, including all the opinions would be helpful, because I've had clients that have what seem to be irrational objections to writing opinions in ways that would not require redaction. That would, but I think that Professor Bell's point that information overload is probably outweighs any additional utility. So I do support keeping the significant adjudicative opinions in.
Thank you, Ray Peeler.
So yeah, I think information overload is certainly an issue. When I thought about this from our federal perspective, federal sector opinions, you know, we might end up attaching 5,000 different opinions to a particular rule. As far as the term significant goes, and you know, courts making determinations, I would say, gosh, Professor Bell, from your lips to God's ears, that they wouldn't make those connections. I think the idea of having some sort of language that might mitigate that would be useful.
Great, thank you. Since I see no other comments, I'm not going to ask us to vote on every single section, but given that this one seems to be particularly divisive, for committee members who are in favor of this, keeping this provision in the way it's drafted at present on the screen, please raise your hand. Okay, and then those committee members who are in favor of deleting this section altogether, please raise your hands. Fabulous. Okay, so let's move on to the next one, which would be 8. Congress should provide. Does anyone have, does anyone think that this is low-hanging fruit that we can just quickly consider, or do we need further discussion? Give you a second to take a look at it. Burke Kepler?
Yeah, just to flag again that we had a pre-submitted comment that would oppose the idea of requiring the expedited processing and not charging the fees for a failure to make the kind of affirmative disclosure that would be required by something like this. Just seems a little punitive on an agency that presumably had made, I think, a good faith decision not to disclose something. So I think would oppose this or ask that this be removed.
Okay, given that it sounds like there needs to be some more discussion, let's skip over it for now. We'll put a pin in it and come back to it and look